So the CCMA has recently found that an employee dismissal was substantially fair because they independently operated a formal business that marketed a meat product. This was despite the fact that the said employee was, or employer rather, was also producing and selling meat products. Let's discuss the do's and don'ts when it comes to moonlighting and side hustles or hustles. We're joined by Osborne Molatudi, employment and labor law specialist at Molatudi Attorneys. Thank you very much, sir, for availing yourself on this Friday. Before we proceed with the conversation, just perhaps to deal with these terms, when we're talking about side hustles and we talk about moonlighting, what are we talking about?
Thank you, Dudu, and to your viewers for having me on your show. Yes, moonlighting is when someone is doing an outside job outside of his formal employment. It's the same as side hustling. It's somebody who embarks on entrepreneurial skills, again, informally or formally, so outside of his formal employment with his employer.
And ordinarily, that is not a problem, as it would be clearly defined in your contract of employment as you enter into it with your employer. But in this case, it was a little bit more complicated than that. It started off at the CCMA, it went to the Labour Court and the Labour Appeal Court. Help us understand why.
Yeah, so in this particular instance, the employee was employed as a sales representative for a meat company. Nothing wrong with that. However, over the weekends, in order to supplement her income, the employee ran what one can refer to as a biltong business. And that, as it appears from the case itself, she did not disclose it to her employer. Now, one thing your viewers should bear in mind is that employees have a duty to act in good faith towards their employers, and this is non-negotiable. Of course, similarly, employers have a corresponding duty to treat their employees fairly. So where an employee has breached that duty of good faith, the employer will be perfectly within its rights to institute a fair inquiry in order to establish the circumstances under which the offense in question has been committed. And this instance, this is exactly what happened. It's something that was bordering on dishonesty and non-disclosure.
And that's just it. On the issue of disclosure in a country like South Africa, where it's very tight for a number of people, even the so-called middle class, that is facing rather immense pressure. So you'll have people that will tell you that it's not merely enough for me to have, one stream of income. How important is it then that you go to your employer and you make them aware of your side hustles or whatever business you're doing on the side?
Dudu, it has become a common practice for most employers to require their employees to do declarations, to make disclosures. So essentially what this means is that employees may be requested to disclose certain side hustles or moonlighting, whatever you may call it, in order for the employer to check whether there's going to be any conflict, or for the employer to actually embrace that and give them an open permission. I mean, think about some of our people in the industry, as well as in the media, etc., who are having side hustling over weekends. They are DJs, they are program directors, etc. They earn an income. So on that basis, if you believe as an employee that there's nothing wrong with what you're doing, then you should similarly feel free to disclose it to your employer. The moment you keep quiet about it, then it means there's something odd about it. So what I can advise those employees who may be caught up in this scenario is that disclose, declare, and let your job be safe.
In the absence of this being an actual contractual obligation that you declare, what then happens? And I ask particularly maybe for people who say, well, I'm a freelancer, and so, my time is divided between however many employees, or maybe not employers rather, but however many people I give a service to.
Yes, I think with freelancers, they may get away with it, but at the same time, there will be some corresponding duties and obligation, because it doesn't necessarily mean that if you are a freelancer, you can do as you please over the weekends. There's a limit, and I'm sure you and I are aware of cases where, contracts of freelancers were terminated because of the things that they did over the weekend. But with employees, I must emphasize that it does not need to be in writing. A duty of good faith can be an implied term of an employment relationship. So an employer doesn't need to tell you that I need to trust you. I need you to act in good faith towards me. The law accepts that it can be an implied term. Yes, more often we hear people saying, love them all, trust no one. Unfortunately, in a workplace environment, an employer expects its employees to act in good faith and to be trusted at all material times in the execution of their tasks.
What do you perceive, sir, was the reason for the various positions of not only the CCMA but the Labour Court and the Appeals Court? Because the Labour Court found in favor of the employee, saying that firstly he accepted that there's no duty for an employee to inform their employer about a potential conflict of interest, and employees only required to inform an employer of a potential conflict of interest where there is competition of some sort. However, the Labour Court then overruled that.
Yes, unfortunately for the employee, the Labour Appeal Court disagreed with the Labour Court in this instance. In this instance, there's something that we call incompatible. I mean, you are a sales representative working for a meat company that sells meat products. Over the weekend, you're selling almost similar to that. That is biltong, a dried meat product. And the Labour Court's view was that it was not interfering with their performance and so on. The Labour Appeal Court disagreed and says there was a duty on this employee not only to disclose, but to get the permission from the employer as to whether or not she can carry out that dry meat selling of biltong over the weekends. And as it turned out, apparently the company in this instance subsequently also started selling biltong. But the bottom line is, if you are confident that that which you are doing, there's nothing wrong about it, openly disclose it, declare it to the employer, and obtain the permission. It's not for the employer to leave it to you to decide whether or not that which you do over the weekends or after hours outside the workplace is in conflict with the employer or not. It's for you, the employee, to actually make that declaration. Remember, non-disclosure has got dire consequences which can lead you to a disciplinary inquiry. So if I'm a DJ over the weekend and I'm a lawyer at a particular law firm, and I don't see any conflict in that, I will openly declare and say, to supplement my income, I'm a DJ. I DJ for some of the parties and I get an income. Remember, Judy, there's also another unintended consequences, SARS. So if you are receiving an income from more than one source, SARS will be more interested as to where is this other income coming from, unless, of course, there are other ways in which you are paid that income. But we all expect to receive our income in this country legally to the extent that we are compliant, not only with the rules and regulations and procedures of your employer, but of the country as a whole.
So, Mr. Molatudi, there are cases where it's clear, right? So if you work for a meat company and you sell biltong on the weekend, clear conflict of interest. If you are a lawyer and then you're a DJ on the weekend, some may say that's like day and night, right? So how important or how much of a factor is the work environment where perhaps you have a line manager that could find a problem with that and say, well, we don't want our law firm rather to be seen in a particular light. How many of those cases do you see where people are afraid to declare because of the kind of environment that they're in?
Oh, yes, indeed. So that goes to what we call a code of conduct. If a code of conduct throws in certain expectations on the part of employees, especially in a professional environment or any environment for that matter, the last thing they need is their reputation and image being tinted or being affected by activities that may take place after hours or over weekends. So on that basis, the employees will be well aware that is what is expected of them, and that is why they will be reluctant to declare and disclose. Take, for instance, I mean, if I'm a DJ in a club and I get excited and the party revelers are dancing to my music, etc., and then I end up using language that is unacceptable. And it so happens that at that club there are high officials, client representatives of a big client of the firm, I can guarantee you on Monday I'll be called to the office to come and explain the use of that language, etc. So that's another topic for another day, but we are expected to behave well at all material times, especially if the code of conduct or ethics of your own employee is so broad enough that it expects you to behave well at all material times, including driving, of course. We all know that.
Sure.
If you are found driving under the influence of alcohol and you occupy a particular position, the employer will be entitled to question you on that, and including taking disciplinary steps against you.
But if we're in the club together, we are there for our own personal pleasures. I'm being silly. I guess the point is declare. If there's nothing wrong, whether you feel there's something wrong or nothing wrong, the point is to declare. Thank you very much for helping us understand this latest development. Osborne Molatudi, Employment and Labor Law Specialist at Molatudi Attorneys.